Thank you for watching this video on bankruptcy basics. This video will explain what bankruptcy is and what happens in a bankruptcy case. This information is provided to help consumers, individuals like you, understand the bankruptcy process. People who are having trouble paying their debts sometimes consider bankruptcy as a remedy for this situation. Bankruptcy is a legal process by which you can deal with your debts when you can no longer pay them. By filing bankruptcy, many individuals find that they're able to get most, if not all, bills discharged, meaning wiped out, keep most, if not all, of their property, and or get extra time to pay bills if you have a regular income. An individual called a debtor usually files bankruptcy to obtain a discharge, which will wipe out all or most of his or her debts so that they will not have to be paid. A married person may file alone or with the person's spouse. Once the bankruptcy begins, creditors cannot try to collect debts from the bankruptcy debtor or sue the debtor to obtain a judgment. With a few exceptions, the creditors have no claim on the debtor's future income or future assets. Bankruptcy is not the only method of dealing with too much debt. In some situations, another way might be more advantageous to the debtor than filing bankruptcy. Such alternatives may include an out-of-court settlement with creditors, reduction of payments to creditors, attaining help from a consumer credit counseling service, or payment of debts by sale of assets or borrowing on assets. However, these methods require some cooperation from creditors, and the chances of success are greater if the debtor attempts these alternatives soon after financial difficulties begin. There are three main types of bankruptcy cases for individuals. These are referred to by their chapter number in the Bankruptcy Code. The Bankruptcy Code is federal, not state law, and bankruptcy cases are filed in the United States Bankruptcy Court, not in a state court. The most common types of cases for individuals are Chapter 7, Chapter 13, and Chapter 11. A Chapter 7 is a liquidating bankruptcy, the most common bankruptcy case. In return for having debts discharged, the debtor must turn over to the Chapter 7 bankruptcy trustee all property except for certain assets which Florida law allows the debtor to keep as exempt so that the debtor can make a fresh start. In most Chapter 7 cases, all property is exempt, and so the debtor keeps all of the property. Those cases are sometimes called no-asset cases. However, when a debtor's assets exceed what is allowed to be exempted, the trustee sells the property and distributes the proceeds to the creditors according to priorities established by law. Very often, there is not enough money to pay for anything more than the cost of administration, and the creditors will receive nothing. The principal advantage of Chapter 7 is that the debtor emerges from bankruptcy without any future obligations on his or her discharged debts, except for certain debts that public policy dictates should not be wiped away. For example, debts incurred through fraud or debts for child support and alimony. A Chapter 13 case is often used by individuals who want to catch up past due mortgage or car loan payments and keep their assets. In Chapter 13, the debtor must propose in good faith to pay all or part of the debts from future income over a period of time ranging from 3 to 5 years. If the court approves the plan of repayment, the debts may be settled in this manner, even if some creditors are not paid in full and are not willing to go along with the plan. If the debtor makes the payments as required, he or she will not have to surrender property to the Chapter 13 trustee. Chapter 13 can be more advantageous than a liquidating bankruptcy for those who are behind on their home mortgage or car loans and for other reasons. For instance, some of the debts that cannot be discharged in a Chapter 7 can be discharged in Chapter 13 once the debtor completes the Chapter 13 plan. Also, the debtor can pay some non-dischargeable federal taxes over the term of the Chapter 13 plan without interest. However, Chapter 13 can only be used by an individual debtor, not by a corporation, and only if the total debts owed are less than certain limits for secured and unsecured debts. An individual engaged in business, not as a corporation, might use Chapter 13 to pay debts or settle them over a period of time while he or she continues to own and operate the business. Another type of case in bankruptcy is a Chapter 11 reorganization. It's generally used by businesses, but can be used by individual debtors who do not qualify for Chapter 13 because their debts exceed the Chapter 13 limit. In a Chapter 11 case, the creditors are temporarily stopped from taking any action against the debtor while the debtor tries to work out a plan of reorganization. Such a plan may involve a method of paying all or part of the debts or claims. The debtor may also deal with taxes through a plan. The creditors vote on the plan, and it must also be approved by the court. The debtor typically uses Chapter 11 to preserve an ongoing business or source of income that might otherwise be lost in a liquidation. Chapter 11 can be complicated and costly. As I mentioned before, some debts cannot be wiped away by a bankruptcy. Bankruptcy does not wipe out most mortgages or liens. If a debtor wants to keep his or her house, the debtor must continue making the payments on the mortgage. If the debtor wants to keep a car which is liened, he or she must likewise continue the payments. A debtor facing foreclosure on his or her home may use Chapter 13 to repay past due payments and other costs while also making the regular mortgage payments and keep the home. However, judgment liens and certain kinds of liens on personal property may be voided if they are liens on exempt property. And in a Chapter 7, certain property can be redeemed from a lien by an appropriate proceeding in the bankruptcy, which would require paying to the lien holder the market value of the property. Also, under certain circumstances, if a creditor or the trustee objects, a debtor may be denied a discharge and continue to owe the debts as if the bankruptcy had never been filed. Some of the reasons for being denied a discharge are fraudulent transfer of an asset to keep it away from creditors or the bankruptcy trustee, concealment of assets, or disobeying or making a false statement to the bankruptcy court. Such acts may also constitute federal crimes for which the debtor can be fined or imprisoned, and we'll tell you more about that in a later segment in this video. Certain types of debts, such as child support, alimony, most student loans, some federal income taxes, and all employer withholding taxes, cannot be discharged in bankruptcy. The debtor's wrongful conduct may make some debts non-dischargeable, such as incurring credit card charges when the debtor had no intent or ability to repay, or obtaining loans using false financial information. The Bankruptcy Code prescribes time periods during which a debtor who files more than one case may not receive a discharge. In other words, a debtor may get a discharge only infrequently. These periods differ depending on what chapter you filed under before and what chapter your current case is under. As I mentioned, debtors in bankruptcy get to keep or exempt certain property that the law permits them to keep in order to start over and make a fresh start. This does not mean you do not have to pay your secured debts, however, such as home mortgages and car loans, for example. What the exemption process means is that a Chapter 7 trustee cannot sell your exempt property for the benefit of your creditors, only non-exempt property. And in Chapter 13 or 11, you do not have to pay your unsecured creditors the amount equal to the value of your exempt property. only the value of your non-exempt property. Here are some of the most common examples of exempt property under Florida law and the Bankruptcy Code. Your homestead, except that the equity in your homestead may be capped or not exempt to a certain extent if you moved here recently, took money from non-exempt assets, and put that money into your homestead, or have not owned your homestead for a specific period of time. $1,000 worth of equity in a car. Wages of a head of a household. Certain retirement plans and IRAs if they qualify. Certain annuities. Disability income benefits. Professionally prescribed health aids. $4,000 of personal property if you do not claim or have the benefits of a homestead, and $1,000 worth of personal property in addition to the personal property I just mentioned. Before you get ready to file, you must participate in a credit briefing session provided by a credit counseling agency approved by the government. In 2005, the Bankruptcy Code was amended to require that most individual debtors complete this special briefing before filing a bankruptcy case. This briefing session is intended to explore whether there is an alternative to bankruptcy in your particular situation. Approved agencies may be found by calling the bankruptcy court in your area or by accessing a list that is linked from bankruptcy court's website. The cost varies, and some agencies will reduce or waive the cost depending on your circumstances. A bankruptcy case is started by filing what is called a petition with the bankruptcy court in the federal judicial district and division where the debtor resides. The petition contains a request for relief under one of the chapters of the Bankruptcy Code. A debtor must file a statement regarding various financial matters and disclose all creditors and assets on forms called schedules. And the debtor must fill out a form showing whether the debtor should be a Chapter 13 rather than a Chapter 7 given the amount of money that is left over each month after deducting reasonable household expenses. This form is called the means test form. Most debtors must pay a filing fee unless the debtor's income is under a certain limitation, in which case the debtor may request a waiver. The filing fee is established by law and varies by which chapter in the Bankruptcy Code you use. The fee is payable in cash, certified check, or money order, and sometimes may be paid in 4 monthly installments upon request. A debtor is required to appear at a meeting conducted by either a trustee or the United States trustee, during which creditors may ask questions regarding the debtor's finances, assets, and liabilities. This meeting is called a meeting of creditors, but some people call it a 341 meeting because it is in Section 341 of the Bankruptcy Code that the meeting is required. When you go to a federal court facility, you will probably have to pass through security checkpoints. You will be required to show a valid picture identification card to gain entry, and an expired driver's license is not considered to be a valid ID. Also, many courthouses and creditor meeting facilities will not permit you to bring in a cell phone, camera, or other electronic device. Let's watch what happens in a 341 meeting.
All right, our next case is Rosario Lopez. Ms. Lopez, please come forward. If you would take out your photo ID,
Sure.
proof of Social Security number, and place those items on the table. Thank you. This is track number 14. This is the Section 341 meeting of creditors for Rosario Lopez, case number 0751316-CPM. My name is Carolyn Cheney, Chapter 7 trustee. The debtor is present, and I have verified her certificate of credit counseling. One creditor is present through counsel. Who do you represent, sir?
My name is Tim Sierra, and I represent City One Credit Union.
Thank you. The trustee has verified the debtor's photo ID and proof of her Social Security number. Raise your right hand for the oath. Do you swear or affirm to tell the truth in this case?
Yes, ma'am.
State your name and address.
Rosario Lopez, 24822 Lima Drive, Tampa, Florida, 33543.
All right. Let me have you speak up a little bit since these proceedings are being recorded, okay?
Yes, ma'am.
Do you own the property you live in?
Yes, I do, and my mom lives there with me.
Okay. Does she help you pay the mortgage?
Yes, ma'am, she does.
How long have you owned the property?
About 4.5 years.
How much is your mortgage payment each month?
It's $1,089.
Does your mother help you pay the household expenses?
Yeah, she gives me $400 from Social Security.
All right. Your schedules show that you own a 2002 Honda Civic. How long have you owned that car?
For about a year and a half.
How much did you pay for the car?
I paid $7,000.
Is that being financed?
Yes, ma'am, it is through City One Credit Union.
Does the credit union actually hold the title to the car?
Yes.
Now for the value of the Honda. How did you come up with the value?
What I did is I took it to CarMax, and they told me it was $5,000. Then I looked at a book somewhere, and it said $8,000. So I took half of what, which is exactly what I paid.
Okay. What book did you mean?
Kelly Blue Book online.
All right. So you took the middle ground.
Yes.
Okay. How much do you still owe on the car?
I owe about $6,200.
Okay. Are you still working with Max Smith Realty as a closing agent?
Yes, I am, but only until June 30th.
And what happens then?
I've been laid off. I have the paper here if you want to look at it.
Not right now.
Times are tough with real estate right now.
So what are you going to do when your job ends?
We'll hopefully get another job with another company or a title company.
Okay. Let's look at your expenses, Ms. Lopez. Let's see, $325 a month to the credit union. And do you buy your own food for the household?
My mom sometimes buys groceries.
In addition to helping you pay the mortgage?
Yes.
Okay. All right. How old are you, Ms. Lopez?
39.
How did you get into this financial situation?
I started with a divorce about 5 years ago. I left Miami and I was divorced shortly after that. And then my ex-husband took me for everything, the house and everything. And I came up here with my mother hoping to get a fresh start, but I actually ended up with more problems. After I bought the house here, my boyfriend and I had this crazy idea, but we decided that we were going to buy a duplex rental, and he was going to live on half of it, and we were going to split the income from the other half. But 4 days after he moved in, he lost his job, and then 4 months after that, we broke up. So I tried to keep up the payments to avoid a foreclosure. And it's just been a downward spiral since then. I have to use credit cards to keep things up. These deals about credit cards will come in the mail, and all of a sudden I was just borrowing from Peter to pay Paul and switching credit cards. Then I had a car accident in an Altima. I wrecked the car, and because I didn't have enough full coverage, it was my fault. And I had no money. I had to buy another car, but I had no money for a down payment or a trade-in. So it's been a nightmare, a real horrendous nightmare, and it never seems to end. That's why my mom moved in here with me to help me.
Okay. It looks like you have 2 lawsuits filed against you.
Yes, ma'am.
One of the suits is for the deficiency on the Altima, and the other is on a credit card.
Correct.
All right. You've given me your tax returns for the last 2 years and your bank statements, and I'm looking at the Bank of the Union check statements. What is this March withdrawal of $1,200 for?
Oh, that was actually a favor that I was doing to a friend. It was a tax check. So I deposited in my account, but then I withdrew it. And you can look up the name online if you like to see that it was not mine. I was just doing somebody a favor.
Okay. I do see a debit and a credit entry.
Yeah, I was doing somebody a favor.
All right. Were you made aware of the different chapters of bankruptcy, Chapter 7 and 13?
Yes, ma'am. The company that helped me put this bankruptcy together, they gave me a piece of paper and we read it together. But I'm not behind on mortgage, so I cannot be in a 13, and I don't make enough money either.
Did you review your bankruptcy schedules carefully before you signed them under penalty of perjury?
Yes.
Have you listed everything you own along with everyone you owe?
Yes, ma'am.
What is your telephone number?
813-555-5554.
Do you have any questions, Mr. Sierra?
Yes, I do. Ms. Lopez, who drives the Honda?
I do, but my mom borrows it sometimes.
And where is it kept when it's not in use?
In the house?
Is it insured?
Yes, it is, through a state ranch.
And can you provide my office a copy of the declarations page indicating that my client is an additional insured?
Yes.
It's my understanding that you're 2 months down on car payments and you're going to lose your job at the end of June. What is your intention in regard to the automobile?
Well, hopefully I'll be able to make a payment next Friday with my next paycheck.
If my client were to take 2 payments, put them on the end of the loan, reduce your interest rate, would you reaffirm the debt?
I'm not sure really what that means, but I think it's something that I should consider.
We can talk about it outside the meeting. I have no further questions.
Thank you. No further questions from the trustee. Your meeting is concluded. Thank you, Ms. Lopez.
Thank you.
A debtor must be very accurate in his or her dealings with the court, including filling out the statement of financial affairs and schedules accurately. These papers and a debtor's testimony at the 341 meeting are sworn to under penalty of perjury. There can be severe consequences for violating this duty. Let's hear from a bankruptcy judge, Judge Paul M. Glenn.
Bankruptcy is not a step to be taken lightly or casually. It's a serious event. It has some real benefits. I mean, it will help people save their homes. It will help people relieve themselves from overwhelming debt. But along with those benefits, there are some serious responsibilities that go along. There's a petition and financial statements that have to be filed when a person files their bankruptcy case. And these are signed under oath. These are sworn documents. They're signed under oath and under penalty of perjury. Sometimes people will transfer vehicles or personal property or things to their relatives or their parents or their kin to hold for them for a period of time while they go through bankruptcy. That is clearly a non-disclosure of assets and is a bankruptcy fraud. So any transfers that have been made within the last period of time have to be disclosed on the schedules. In addition to the oath that goes along with the signature, all the papers are signed under one of the rules of the bankruptcy courts, and that is the signature is a certification that to the best of the person's knowledge and information and belief, the representations are accurate, the facts are accurate. The consequences of not being candid and not being truthful on the schedules, there is a criminal law that says that if anyone files a petition or files a document that makes a false or fraudulent representation, then they are subject to criminal prosecution, which provides for fines or imprisonment even up to 5 years, or both of those. So it's a serious crime if there are material misstatements that could be prosecuted. The consequences of fudging are just too severe to risk. You risk the discharge, you risk committing a crime, and the chances are likely that you'll get caught because the trustees who review these schedules in the trustees meetings review thousands, and they see thousands of people. They know the questions to ask. The questions that they ask in the meeting have to be responded to under oath, and then creditors come to the meeting, and creditors are able to have their input as well. The likelihood that non-disclosures will be found, and if they are, then there are serious consequences to that. Sloppiness and gross negligence are among those criteria that will lead to the conclusion that the omission is intentional. Take your time, get it right, and be honest.
Depending on the chapter under which the bankruptcy is filed and the complexity of the case, the debtor may also be required to appear at hearings before the bankruptcy judge. A typical example is a reaffirmation hearing in a Chapter 7 case where the debtor wants to reaffirm a debt secured by, say, a car or home furnishings, But the judge must make sure the debtor can handle the payments before the judge will approve the agreement. Generally, however, a debtor's involvement with the bankruptcy judge is usually very limited. A typical Chapter 7 debtor will not appear in court and will not see the judge unless an objection is raised in the case or a reaffirmation hearing must be held. A Chapter 13 debtor may only have to appear at a hearing for the court to confirm, meaning approve, the Chapter 13 plan. As an aside, you should know that proceedings of the court are serious and dignified. All persons appearing in court should therefore dress in appropriate business attire consistent with their financial abilities. Among other things, a coat and tie are appropriate for a man. A dress or pantsuit is appropriate for a woman. Some courts have men's jackets available as a loaner for court appearances, but most do not. Let's watch what goes on in a typical hearing on whether a debtor's reaffirmation agreement should be approved.
Case number 07-51316, Rosario Lopez.
Good afternoon, Ms. Lopez.
Good afternoon, Your Honor.
Ms. Lopez, the Bankruptcy Code requires that whenever someone wishes to reaffirm a debt, that I must hold a hearing at which I discuss with you the alternatives to entering into the reaffirmation agreement, the consequences of doing so. I also must make a finding that it's in your best interest and doesn't impose an undue hardship on you. First of all, with respect to the alternatives, one alternative, of course, is reaffirming the debt, and that's why you're here. Another is that I could approve an arrangement where you buy back the car. It's called a redemption, based on the value of the car as determined by me. Sometimes that's less than the amount of the debt. The only problem with that is that you have to come up with cash to do that. The third alternative is called a surrender. It gives you the opportunity to give the car back and be free of any further liability. That's something that's worth considering if the car payments were beyond what you could reasonably afford. If you do reaffirm the debt, the consequences are that you'll be liable on the full amount of the debt, and if later on you have financial problems, they can not only repossess the car, but they can put it through the auction and come back against you for anything that's left over after applying the auction proceeds against the debt. Finally, I must find that the agreement's in your best interest and doesn't impose an undue hardship on you. Let me ask you, now that we've discussed those alternatives, do you have any questions?
No, Your Honor.
And do you still want to proceed?
Yes.
Okay, now this automobile, as I understand it, is a 2002 Honda Civic.
Yes, Your Honor.
Are you current on your payments?
I am 2 months behind on my car payments.
Okay, so you're 2 months behind. Do you have any arrangement where you can catch that up with the lender?
Yes, the attorney for the creditor told me that they could put those 2 months that I'm behind at the end of the loan, and they will also be willing to reduce the interest rate to decrease the monthly payment.
That's very important, because once you reaffirm the debt, if you are behind, they could come after you immediately for those past due payments. Now, is this a car that you drive personally?
Yes.
Do you need the car to get back and forth to work? It's your primary means of transportation?
I drive it, and I use it to go to work, and I also take my mom to her medical appointments.
Okay, very well. Well, based on that, I will find that this agreement is in your best interest and doesn't impose an undue hardship on you. I'll enter an order to that effect. You'll get a copy of that in the mail. In the meantime, just make sure you stay current on those payments.
I will.
Okay, thank you very much, Ms. Lopez.
Thank you, Judge.
Recall that I told you that most debtors are able to discharge or wipe away most or all of their debts. In order to get a discharge, in addition to meeting the debtor's other duties in bankruptcy, an individual debtor must take a personal financial management course after the case is filed. The time for taking this course depends on what chapter you file under. As with the pre-bankruptcy credit briefing session, approved providers of the course may be found by calling the bankruptcy court in your area or by accessing a list that is linked from bankruptcy court's website. The cost varies, and some agencies will reduce or waive the cost depending on your circumstances. Once you get your discharge, creditors may not attempt to collect any discharged debt. If they do, the debtor can file a motion with the court, reporting the action and asking that the case be reopened to address the matter. The bankruptcy court will often do so to ensure that the discharge is not violated. The discharge constitutes a permanent statutory injunction prohibiting creditors from taking any action, including sending a demand letter or the filing of a lawsuit designed to collect a discharged debt. A creditor can be sanctioned by the court for violating the discharge injunction. The normal sanction for violating the discharge injunction is civil contempt, which is often punishable by a fine. Notwithstanding the discharge, you may voluntarily pay back any discharged debt should you choose to do so. As in any court, individuals have a right to represent themselves before the bankruptcy court. However, bankruptcy is a complex area and involves many considerations, including whether to file, the election of the appropriate chapter, and the selection of exemptions, understanding all of the protections of the bankruptcy code and using them to the debtor's advantage. The right decision for you depends on an evaluation of your family status, your assets, your obligations, and other factors. It is a very serious step that could affect you for the rest of your life. It is possible in a bankruptcy that a debtor will lose all assets and still come out owing all of his or her debts. A lawyer can explain to you how the process works and can help you reach an intelligent decision. Some debtors use non-lawyer bankruptcy petition of filing services to complete the schedules and documents which must be filed with the bankruptcy petition. While this may cost less initially than consulting an attorney, these non-lawyer services by law cannot give legal advice or represent the debtor in bankruptcy court. If a problem arises, they will not be able to help you in court. If you are contemplating a Chapter 11 or Chapter 13 case, then the need to be represented by an attorney is even greater. Certain complexities in the law make it extremely difficult for a debtor to successfully conclude a Chapter 11 or Chapter 13 case without the assistance of an attorney. A corporation cannot represent itself in a bankruptcy case and must be represented by an attorney. If you need a lawyer and don't know how to find one, many areas in Florida have lawyer referral services listed under Attorney or Information and Referral Services in the yellow pages of the phone book. This service will give you an appointment with a lawyer for a nominal fee. If there is no lawyer referral service in your city, the statewide Florida Bar Lawyer Referral Service can locate a lawyer for you. You can call this service toll-free at 1-800-342-8011. That's 1-800-342-8011. The statewide service, which operates only in cities where there is no local program, will refer you to an attorney for an initial 1/2-hour consultation for a reduced fee. Some debtors may be entitled to the services of a lawyer for free or at a reduced fee, depending on their annual income and number of dependents. For low-income lawyer programs in your area, you should check the following websites: www.floridabar.org. Then hit the link to Public Information. Then hit the link to Legal Aid Pro Bono for a link to the list of all legal aid offices in Florida. www.floridalawhelp.org for a legal services directory. www.floridalegal.org for a list of legal assistance provider programs. I hope you found this video informative and helpful to you as you ponder whether bankruptcy is the remedy for your particular situation. If you have any more questions about bankruptcy, you may obtain informational brochures from the Bankruptcy Court, and you may access additional information at the Bankruptcy Court's website, which includes useful links for debtors. One good link is the link to the Bankruptcy Basics document published by the United States Courts. That website is www.uscourts.gov/bankruptcycourts/bankruptcybasics.html. Remember, bankruptcy laws help people who can no longer pay their creditors get a fresh start by liquidating their assets to pay their debts or by creating a repayment plan. Good luck with your fresh start.